Am I pronouncing how Vicelio?
Vicelio.
Vicelio.
I pronounce it. Oh, thank you. May it please the court, Diane Tutt on behalf of the Addison appellants. May I please reserve 5 minutes for rebuttal. We've raised a number of issues in our appeal, and there's 3 issues on the cross appeal. I'm going to address the issues that I think are most important for the entire appellate process, and any issues that I don't get to, I will rest on my briefs. Our first issue is very simple, and the case law is directly in our favor, and that is where damages are duplicated against multiple defendants, i.e. they're severally liable, joint and severally liable, the judgment must say so. And the judge in this case recognized that the damages were the same in many cases. There's just like one difference as to 2 of the defendants. And yet the court didn't want to issue the judgments jointly and severally on their face because the judge wanted the Vicelios to be able to decide which judgments they want to execute on, and he didn't want to avoid any issues with their attorney's fees.
But the judge understood, in fact, I think it was referenced in one of his orders, which I'd point out were extensive, and frankly, he should be applauded for the effort and that Judge Kaiser put into these orders. I don't think I've ever seen in 20 years on the bench that kind of order on a bench trial. But to that extent, the judge recognized that there would not be double recovery.
Yes, I understand that.
The plaintiffs could pick and choose.
Right.
He just want to make sure they collected.
No question, and I do concur with your view on Judge Kaiser's efforts. I mean, this was a huge trial, huge orders, et cetera, and we're not taking the position that any of the factual findings were questionable at all. We've just raised some legal issues, and what I argued in my brief is that it's all well and good for Judge Kaiser to say you can't get double recovery, but what happens if there's no execution for a couple years? Does the clerk have to look in the record to see where the judge said that? It's a very simple matter to make the judgments joint and several. Didn't have any case law when I filed the brief, but in October, this court decided the Shannon versus H&R case, which is case number 4D16.
That case really doesn't go into any detail, though. I mean, I believe you filed that as supplemental authority, and I looked at that, and quite frankly, I can't glean from that opinion the issue that we are faced with. Whether the court, the panel in that case, addressed the issue that we're grappling with, which is...
I thought it did, only because our argument is very simple, that on its face, the judgment has to say joint and several in order to avoid future problems. And that's the issue. I don't want to spend any more time on that, Your Honor. I'm going to go on to, I think, which is the meat of both the appeal and the cross appeal, or the set-off issues.
So essentially on that issue, you're asking us to simply send it back and require the judge to say jointly and severally?
Yes.
Okay.
Well, but there are different counts, and you want to say, how would you want
Well, all the damages are the same except for 2 of the defendant groups, or Addison Development and the Santises, were not limited in the award of consequential damages, so their damages are higher. But all of the damages are the same for everything, for fraud and for breach of all the contracts. So I think, you know, there have to be some recognition that as to the larger judgment, only Addison Development and the DeSantises would be jointly and severally liable, but as to the other amounts, that the rest of the defendants would be. It's as complicated as this case has been. I think that would be a simple ability of the judge to handle. He just didn't want to do it because he thought, frankly, that my saying you can't get double recovery is enough. And we're just saying, I don't think him saying that at a hearing or even an order is enough, because later no one should have to search the record. The setup. Okay.
Just out of curiosity, if you go execute, I mean, on an unsatisfied judgment, who checks whether or not you've gotten a double recovery because you've recovered over something? I mean, even if it says jointly and severally.
Well, if you have a satisfaction of record.
But then what would happen is if you're concerned about this, the first time that they come in and get some money, they go in and they say, okay, now I want a partial satisfaction from you for this amount of damages. And then they sign.
Each defendant could do that, yes, but what's to stop, and I'm not saying that the Vitellios would do anything underhanded, but who knows who has what insurance and where these executions might fall. What I'm saying is, even if someone gets a partial satisfaction, later, the clerk in executing on a different judgment won't know that that was joint and several with the executed.
How does the clerk make the determination that if they've got a partial satisfaction and the judgment is joint and several somehow, that the clerk knows it can't execute? I mean,
I think that's what that means, Your Honor, is that if you have a joint and several judgment against two parties, let's make it simple, against two parties, $100,000, and there's a partial satisfaction for $50,000 in the record as to one, I think the clerk knows they can only get 50 against the other, because that's what joint and several means.
I don't think that's how that works. I think the mechanics of it is the plaintiffs will go in and get a writ of execution or garnish an account, and, or, if there's an insurance company, you have to go in and third party in the insurance company to sue on the policy if the insurance doesn't write a check. And, you just keep getting satisfactions until you're satisfied. And one or both or none of these defendants are going to have to pay one way or the other. One may get saddled with the entire judgment. Who knows?
I understand.
I don't know that there's a problem. I was just curious. So
Right.
essentially, all you want us to do, if we agree with you, you want us to send it back and say, Judge Kaiser, just put joint and severally in there and be done with it.
Yes, exactly.
You're not arguing that somebody isn't responsible,
No.
could not be held 100% responsible?
No, no,
Okay.
not at all. On the set-off issue, the appellants have raised a set-off regarding the fraud judgments. The judge allowed the set-offs against the breach of contract judgments, but not against the fraud judgments, even recognizing that the damages awarded in the fraud judgments were encompassed in the breach of contract damages. So the damages are the same.
Yeah, but you understand the elements of fraud are totally different than the elements of breach of contract, breach of, I mean, that's the law. They might mirror the same damages, but the reality is, and the case law is very clear. I know, Judge Warner's been on a number of these panels and written really the law in this district. We look at the elements and we look at the damages.
You look at the nature of the claim, certainly, but what you really look at is the damages. Under the statute, 46.015, it says that you get a set-off where there's been a prior settlement in partial satisfaction of the damages sued for. And we've cited several cases that talk about, you look at the damages that are entered against each defendant, not the cause of action, not the conduct of the defendant. Judge Kaiser refused to apply the set-off to the fraud judgments.
what were the damages that were recovered under the fraud judgment?
There were two line items on the Vitellios damages list. One was for hardwood flooring, and one was for mold remediation. It was about $78,000.
And
And
those were the same,
They were also included in the breach of contract. The judge found that. The judge said, I know that the damages are the same, but I think the conduct of fraud, I cannot do a set-off. And we say that it's not the conduct, it's that the damages are the same, because if you don't give a set-off, then you're allowing a double recovery merely because the conduct is different for fraud. And the cases that we've cited in the brief are the Escadot case, which is in the 3rd District, 211 Southern 3rd, 1059. We've cited this court's ruling in Centex Rooney, 706 Southern 2nd, 20. And we've also cited Acadia Partners. In Centex Rooney, this court said, we find that the county's claimed damages were not separate and distinct from the damages compensated by its settlements, thereby requiring the court set-off to prevent double recovery. In Centex Rooney, the settling defendants were sued for negligence, and the defendant which went to trial was sued for breach of contract. I realize that it didn't involve fraud, but the important point is that if the damages are the same for two counts, no matter what the conduct is. The statute itself and the case law says that you only get one satisfaction of those damages, no matter how many different claims there are. So we are asking the court to reverse and remand to apply the set-off to all of the judgments because the damages are the same. There's a slight different issue with regard to Mr. Swanson individually. The jury trial was against Mr. Swanson because he wasn't subject to an agreement that waived jury trial. The same amount of fraud damages was awarded against Mr. Swanson by the jury, $78,000. The jury there wasn't a line item on the verdict to say, now, which items are you awarding? But the total was the $78,000, which in the later lengthy non-jury trial, the judgment against the non-jury defendants, the judge found $78,000, same amount as to the non-jury defendants. And as I said, the judge in the non-jury order said it's these two line items I'm awarding, the hardwood floors and the mold remediation. The judge, as a secondary argument on not allowing a set-off to Mr. Swanson's fraud judgment, said that he wasn't going to speculate as to what the jury had based its $78,000 on. And we submit that you don't have to nobody has to speculate. The amount was exactly the same, and it was an odd number with dollars and cents. So there's no way that the jury could have selected any other damages besides those two line items. And as I pointed out in my brief, this is not unusual to have a jury give an award on an undifferentiated verdict, a general verdict, where everybody knows that that's a certain element of damage. In fact, in this court, in the Bouvet, B-E-A-U-V-A-I-S versus Edel case, assumed that the amount that was on the verdict was for medical bills, because it was the exact amount of medical bills, even though the jury hadn't written that. It was a general verdict. So for all of the defendants, the court should have issued a set-off for the fraud judgments as well, based upon the authorities that I cited, as well as the statutory language. Also on set-off, I'd like to address the plaintiffs are arguing, the Vitellios are arguing, that we shouldn't have gotten a set-off at all. And they've made a number of arguments, but it's important to note the reasoning, the main reasoning of the trial court in giving the set-offs, the entire amount of the amounts paid by settling subcontractors as a set-off, was the case law, which is cited in the briefs. There's no argument that these cases don't say this. All of the cases, the Sentex-Rooney case out of this court, the Cornerstone case out of this court, the Dionese case, which started in this court and ended up in the Florida Supreme Court, all of those cases hold that when you have an undifferentiated complaint where you sue multiple defendants for the same damages, and then you settle with some of them, which is what occurred here, and you don't specify or differentiate in those settlement agreements what those people were paying, then as a matter of law, because it's undifferentiated, the defendant that didn't settle gets a full settlement for the entire amounts paid by the settling subcontractors. So there was solid law to support that argument. The Vitellios make several arguments to try to get around that law. They say, well, none of those cases involved a situation where when we went to trial, we didn't put on evidence of the scope of work that these subcontractors had been responsible for. Well, none of the cases make an exception to that, and in fact, in the Cornerstone case, which is one of the cases that we rely on out of this court, that's at 163 Southern 3rd, 565, the plaintiff made a very similar argument, which was rejected by this court. The plaintiff in that was a case by a business against a bank for conversion based upon an employee of the business having embezzled some funds and the bank cashed the checks. The plaintiff argued that even though this embezzler had paid monies to the plaintiff, that the defendant shouldn't get a full set-off because the business was not able to recover its full damages in the trial because of some of the claims were barred by statute of limitations. And this court said, no, the law is, citing these cases that I just talked about, that if you have a complaint that alleges multiple damages, you have a release that doesn't specify, the defendant gets the entire set-off for all of the amounts paid by the settling defendants. And that's what we have here.
May I just ask you,
Yes.
I got to take you back to fraud for a second.
Okay.
You made some statements there, and I just wanted to check something in my notes. You would agree that if one of the defendants pays the amount, and it's the 78,000 flooring, and I think it is flooring, right? That's it? That's, what does it say?
For the
What-
fraud was hardwood flooring and mold remediation.
Mold. If one of the defendants pays that amount to satisfy the compensatory damages, which would have been, that was under breach of contract or breach of warranty?
Breach of contract.
Breach of contract. The fraud, they're not going to get another $78,000. Again, the same principle would apply. You're not going to get double recovery. If there was an attempt to attach and get another $78,000, defendants would go into court and seek a stay of the execution, et cetera, et cetera.
You are right, Your Honor, but let me tell you why we've raised it. With the set-offs, there wouldn't be any fraud judgment. There wouldn't be any judgment against Mr. Swanson individually. So that was the only judgment against Mr.
Yeah, but
Swanson.
he was found to have committed fraud, so if the plaintiffs can't collect it from the other defendants, they have the right to go
Well,
against
unless there's a set-off.
Mr. Swanson. Why? He doesn't get,
Why shouldn't he get a set-off if the same damages were paid by the settling defendants?
because it was fraud as opposed to breach of contract or breach of warranty?
Judge, that's never been raised by the plaintiffs. They have never argued that there shouldn't be a set-off because of a fraud count. They've made some other arguments, which I probably don't have time to address.
We'll hear from Appalachia.
All right.
But you agree there wouldn't be double recovery in any event?
There shouldn't be,
You're
based,
in, on this appeal, you're into your.
I know.
And because you're going to do this twice, we're going to probably hold you pretty much.
I understand.
Okay.
May it please the court, I represent Leo and Catherine Vaselio. May I reserve 5 minutes on the cross appeal?
Yes.
All right, I want to address.
Warner, she's pretty smart. I hope she'd keep track of all these cross appeals and rebuttals and everything else.
All right, well, let me address in order. The first issue was separate damage awards, and I think the court is on that. It was not an abuse of discretion for the judge to do it that way. Each of the three judgments have slightly different defendants because different defendants were parties to the three contracts on which he made those awards. There's also a supersedious bond posted in the total amount of the aggregate items of damages so that they can't collect more than that. But you're right, a defendant against whom collection is attempted has to pay attention and see what satisfactions are issued, and this happens in every case where there's multiple defendants and multiple awards.
Well, do you think, is it error to, based upon like the Shannon case, which said you've got to clarify this, to not say it's joint and several or something there? Or do you think that it should just go and they should raise the satisfactions as they come?
Yes, and I
Is the
think
parade of horribles that council has suggested there, or, I mean, what happens? I've never actually thought
Right.
about that when you have multiple parties that may be individually liable for the same amount of damages.
I don't see how joint and several would change anything, right? Because they can go against either defendant for the same damages. Really, you have to pay attention, watch the partial satisfactions. If you have any doubt, as the judge said, you seek a stay of execution, go to court and figure out what they've collected. That's just what has to happen, whether you have joint and several or not. There's no case law that requires the court to have entered these judgments joint and several. And the Shannon case doesn't do that either. As the judge said, it's a very short opinion, just says you can't collect twice. And the Vaselios acknowledged that in open court. Everybody acknowledged that. And then the supersedious bond provides additional protection. Moving on to set off against fraud, I think counsel was confusing the issues, saying that if the same damages are sought in the contract count as in the fraud count, you get a set off. No, it's really just a double recovery issue that counsel is concerned about, and it's the same answer as that first issue. you have to pay attention. You're not entitled to recover the same damages under fraud and contract, but the judge can award them, especially where you have different defendants. Mr. Swanson, for example, is not a party to any contract.
So you're not worried about double set-off as the plaintiff's attorney? You're not worried about, in some way, shape, or form, the way that Judge Kaiser set up the set-offs, that it's going to end up diminishing the judgment that you're entitled to?
Well, no, the judge said that the real set-off against fraud issue is whether a set-off for the settlement proceeds received is appropriate against fraud. And what the judge said is there's no conceivable way that anything that the 10 settling subcontractors did could have caused Swanson or the other defendants to be liable for fraud. Their fraud was based on misrepresentations of commission and omission. The settling subcontractors had nothing to do with that. And so the 2 damage items that the judge awarded were based on the harm caused by the fraud. So there's no basis to set off settlement proceeds received by the settling subcontractors because the settlers couldn't sue the settling subcontractors for fraud. They couldn't get those damages as fraud damages against the settling subcontractors, even if they'd gone to trial with them. That's what the judge was saying.
Well, if the subcontractors, the settlement was for the cost of the floor, and the fraud judgment is for the cost of the floor, you're saying there still wouldn't be a set-off there?
You can't collect for the same item of damages twice, but the damages caused by the fraud were not damages caused by the settling subcontractor.
but-
That's what the judge, for example, it was the QEC investigation was the largest part of the damages. That was a professional that had to come in and investigate the source of the mold and water intrusion issues, and that happened, the judge said, because of the misrepresentations by Addison, not telling the plaintiffs, yeah, we had water intrusion problems before. So the settling subs didn't do that. They weren't interacting with the Vasilios at all. They weren't the seller. They weren't a representative of the seller.
Well, but the statute, which 4615 says that they should be used as set-off in partial satisfaction of the damages sued for, not necessarily the cause of action.
Right, and as the court said, those damages were not sued for against the settling subcontractors. The fraud damages are damages that occurred only because of misrepresentation, not because of construction defects. The 10 settling subcontractors, the only issue against them is whether they defectively
Well, but the
constructed
damages
things.
were the same. You're saying even though it's the same, the damages sued for, aren't the damages the cost of replacing the floor, which there was a fraudulent misrepresentation for, or was a breach of contract?
The floor wasn't defectively constructed. So
Well,
they're-
I'm just
yeah,
throwing
yeah.
that out as.
So theoretically, yes, if the Vasilios were seeking damages against a subcontractor for improper construction of that floor, and that same amount was somehow related to the fraud and the damage occurred because of fraud, then you can't collect that twice. But that's not the case here. The damage to the perfectly good floor was hurt because of water intrusion, and the misrepresentations came with respect to that, which caused an investigation to take place that didn't really have to take place. So it was the costs of that were the fraud damages. Those are not damages that were sought or could have been sought against the settling subcontractors. That's the real set-off issue.
Are the amounts the same, though? Aren't the amounts the same? 'Cause
Well, now you're
saying
talking
they're-
about the 2 different fraud claims, actually. The amount of fraud damages awarded against Swanson is the same amount as the fraud damages awarded against the other defendants, and that's a different issue. And the judge is not permitted to guess what the jury awarded those fraud damages for. I agree, the amounts are the same, and the judge surmised that maybe that's what they were awarding because those 2 damage elements add up to that number. When the judge made his award against the other defendants, he did specify those 2 damage items. He said, this is what I'm awarding them for, the QEC investigation and the hardwood floors that got hurt because of your misrepresentation. But we can't presume that with regard to Swanson. Nevertheless, that doesn't change the set-off issue. If the jury didn't identify that, you can't prove that the same damages awarded with respect to Swanson were damages sued for with the settling subcontractors.
Even if they're identical
Well,
in amount?
this is a different issue. I'm comparing the damages against the settling subcontractors with the damages awarded for fraud with Swanson. You're talking, I think, now about the damages awarded for fraud against one party versus the damages awarded for fraud against the other parties.
You're confusing me.
I'm confusing myself.
You said something about the investigative costs,
Yes, QEC is the name of the company.
and those were the fraud damages, which were the $78,000, and they just happened to be this exact same dollar amount, as the cost of the floor and the mold remediation?
No. The total of the floor, which was about 28,000, and the investigation, which is about 50,000, is the 78,000. And so the damages awarded for fraud against the corporate defendants by the judge in the bench trial is for those two items, because the judge said so. The jury also awarded the same amount earlier against Mr. Swanson. The judge kind of guessed that that's what those damages were for, but he ruled that I can't, based on case law, I can't surmise that. But I'm awarding fraud damages based on those two items because I believe that is the harm incurred based on the fraud.
Okay, and so the subcontractor set-off may have had the cost of the floor, but it didn't have the cost of the investigative damages.
It wouldn't have had the cost of the floor because that was only hurt by water intrusion. The settling subcontractors didn't cause that. If they defectively constructed the floor, which caused water intrusion, that's not the case. That didn't happen. It was just flooring that got hurt because of another cause.
This reminds me of Who's on First.
Yeah,
Bottom line is, though, that nobody's going to pay that 78,000 twice.
that's correct. That's right. They shouldn't have to, and that's been acknowledged on the record. I want to move on to the set-off issue. The complaint in this case, the operative complaint was the second amended complaint. In count 1, listed the subcontractors on a code violation claim. The plaintiff decided to sue not just the contractor, but also the contractor's subcontractors, probably because there was concern about whether the contractor would ever be collectible. The only claim they could bring against the subcontractors was code violation because there weren't direct contracts, no contractual privity. The subcontractors weren't in privity with the buyer. So the Veselios sued for code violation and also sued the contractor on that same claim. That's count 1. The structure of the complaint is critical here because this is what I believe confused the judge to rule that a set-off should apply in the entire amount of the settlement proceeds. The complaint lists all these defendants, 15 of them, 12 subcontractors, and then the Addison companies and Mr. Swanson, 15 of them, then lists all the different kinds of construction damages. The pool was leaking, there's some electrical conduits that are incorrect, there's some damaged stucco or incorrectly and stuff. Lists those damages. But it doesn't say which defendant is responsible for which damage in the complaint. It just lists all the defendants and lists all the damages. You remember the matching tests we took when we were in grade school, and the teacher would put, here's the list of 8 presidents, 1, 2, 3, 4, 5, 6, and here's the terms of office, A, B, C, D, and you have to draw a line to match them up, right? This complaint doesn't do that. It just lists all the defendants, lists all the damages, and then it lists the categories of damages. It says direct damages and consequential damages, including loss of use of the home, security to keep the home guarded while there was construction work going on, all the windows and doors had been taken out, staff and to take care of personal property and keep it safe while windows and doors are out, and to move things as they needed to be moved to be preserved and protected. So, and it doesn't say which defendants are responsible for those or which part of them. The wherefore clause says we sue these 15 defendants for all the damages we incurred. That's it. Fast forward. Before trial, there are settlements with 10 subcontractors, specific subcontractors. Allard Pool, who did the swimming pool. A painting company, the electrician, the plumber, the stucco guy, 10 different subcontractors. The trial court had to decide what to do with those settlements. And the parties were concerned about it too. Really, neither party wanted the jury to have to think about all these 10 settling subcontractors who were out of the case or the
You're
work
the
that
one
they
that
did.
moved to exclude
Yes.
and eliminate the set-offs,
Absolutely.
the settlements.
Yes, with a specific
And
purpose in
during
mind.
that, I mean, the transcript was pretty clear on that you said that, I understand we're going to have to deal with set-offs later on.
Right, and a set-off could have still been appropriate if evidence did get in somehow that should have been excluded. This is a very complicated trial, and the judge wasn't willing to decide ahead of the trial whether there would ever be a set-off. He'd have to say, he was a very cautious judge. Let's see what evidence comes in, and we'll revisit that after the trial. So based on the motion in limine, which the defendants agreed with, the Veselios withheld evidence of damages caused by the 10 settling subcontractors who would no longer be at the trial. That amounted to $5.1 million of construction damages, for which the Veselios received $2.725. I'll just say $2.7 million in settlement proceeds. So the agreement was the jury's not going to hear about settlements with other defendants who used to be in the case. And they're never going to see the damages, the construction damages caused by those 10 subcontractors. And the Vasellos agreed in these settlement agreements not to pursue Addison, the contractor, or the seller for those damages caused by the settled subcontractors. That was the agreement. And that was it. That was the end of it. Through trial, the Vasellos honored that agreement. There were many times during the trial when the defendants, usually Addison, came to the bench and said, we think this damage item is something that really should not come in. And the judge would deal with it. And a couple of times he sustained the objection. Most of the time he ruled, well, no, that's not something against the settled subcontractor. That can come in. So the judge did marshal the evidence through the trial. At the end of the trial, it came time, the judge enters the judgments, subject to possible set-offs. The defendants move for set-off. They don't argue the theory that the judge ultimately decided the set-off on, and that's the important thing here, the judge's theory. The judge decides at the set-off hearing that in looking at the settlement agreements, you've released each settled subcontractor for anything you could have sued them for, and even though it says you've reserved your right to sue Addison for anything that the settled subcontractor didn't cause, that's in those settlement agreements too, your complaint, you remember I said it lists the defendants, it lists all the damages, it doesn't say who caused what. The judge said you were suing each defendant for all the damages, whether that's factually feasible or not. And so he said, because you did that, you settled all those damages, and so the entire amount of the settlement has to come off of the judgment amounts that I've awarded, even if you're...
Well, but he also based it on your release, because the releases that were used were general releases, and the case law of our court is pretty clear. I mean, we have cases where the one case that comes to mind was $250,000 settlement, and they made the attorney's fees $245,000 and $5,000 in compensatory, and because the settlement agreement delineated $5,000 in damages, that's the only set-off, even though, you look at it and go, wait a second, what's going on here? But the case law is pretty clear, and rightfully so. I mean, there's an analysis of why that's the law, because we don't want to put trial judges in a situation of having to figure out factually what was really going on during these settlement discussions.
There's two ways for the court to have handled the settlement proceeds. The court could allow all of that damage evidence to come in, even though they've already settled with the subcontractors, award whatever damages are appropriate, because the contractor would be liable also for damages committed by its subcontractor or caused by its subcontractor, and then apply the entire set-off of the settlement proceeds. That would make the trial somewhat longer, and parties were concerned that that would be very confusing to the jury. Each side thought they'd be prejudiced by that. So they didn't do it that way. The second way is to withhold the damage evidence of damages caused by the settled subcontractors, and then you don't get a set-off unless there's a mistake made in evidence that comes in, essentially. $5.1 million in hard construction damages were withheld from evidence for $2.7 million. Looking back at it, if the judge had said up front, even if you withhold damages evidence, based on the language of the complaint and the releases, I'm going to subtract all of the settlement proceeds anyway, well, the sellers would have said, well, okay, then we'll just put on the damages evidence. It'll lengthen the trial, and that would have been easier. It would have been longer and would have been more confusing for the jury. But that's what usually happens in cases. You just put on all the damages evidence. None of the cases relied on in the courts.
Was there a stipulation that you do it this way, but you would still be, and that the settlement somehow would make the settlements not be set off? I mean, did you make that agreement?
There's no express agreement. That was the intention, but the point is everybody said, we'll deal with set-off later. We'll decide that later based on what evidence actually comes in. And that, with this judge, that was a reasonable decision to make. They weren't going to be able to settle set-off, and these parties were all contentious. That wasn't going to happen. So what has to happen in a set-off analysis is determine whether the damages recovered in the trial really are the same damages for which these settled subcontractors were sued.
Yeah, but you could, like I said, I mean, that's the whole point of these releases. I mean, the case law out of our court is pretty clear, and it provides the guidance necessary. I appreciate what you're saying. I mean, some of it is speculation, not in the record. For example, the additional $5 million that you said you could have proved in damages, but I mean, that's all well and good, but, you know, the case law is pretty clear, and it seems sound to me that, we just don't want to burden the trial judges with having to go through this. I mean, on both sides, there's ways to protect yourselves.
Well, the
And I
trial judge,
appreciate your dilemma, but
the trial judge would have had a burden if they would have done it the other way, admitted all the $5.1 million of evidence of 10 settling subcontractors. It would have brought a bunch more people, witnesses, into the case, and there'd be fights about, what parts of that damage is really caused by the settled subcontractors. Trial would have been longer, and then the judge would have had to do those calculations, determine how much of that is awarded, and then apply the set-off. But here, the parties chose a different method, and that's what separates this case from all the cases relied on by the judge, the Centex case, Cornerstone,
the
Diney's.
parties chose a different method.
Yes.
I mean, my reading of what went on was, you guys moved in lemonade because you didn't want the jury to hear that you had gotten $2+ million, which I certainly understand from a strategic standpoint at that moment in time. I got to be honest with you, it made perfect sense. Because you're trying, you've got a lot of money involved. You got the plaintiffs may not be so sympathetic. What was that, a $40-something million house?
Yes.
I mean, I get all that. That's,
Right.
the lawyers, those are the decisions we make as lawyers. But the reality is that it looked pretty loosey-goosey to me.
The
In
plaintiff-
terms of what you all, I didn't garner that there was any methodology that was going to be used, as Judge Warner asked, that it was going to be, okay, let's see what happens, but we want to get on with the case, and both sides made a strategic decision
Well,
not
right,
to
the
be
defendants-
loosey-goosey.
Right, the defendants agreed with that too, but that doesn't mean that they can get a set-off for non-duplicative damages. I mean, the judge said the only damages that are duplicative are these consequential damages, and they were primarily based on the Veselios having
You're
to...
presuming non-duplicative because, for example, you'll take the pool contractor, well, we know there was no damage. I mean, water damage to the pool. But then there was some testimony that the pavers might have been damaged by the pool contractor. So, who knows? That was never, because it was never delineated, I think you're now putting the burden on the trial judge to have a second trial, and that could have been taken care of with these releases. That's the whole point of the law in this district.
Well, I mean, the set-off hearing does require evidence sometimes. You said the $5.1 million was not in evidence. It was at the set-off hearing. The same damages expert took the stand and said, here's the damages we withheld. And the other side didn't put any witnesses on. They cross-examined for a couple of minutes, but they didn't put any evidence on to show that these settled subcontractors could have caused the consequential damages that the judge found to be duplicative.
Okay, you have used up all your time. Do you
I
wanna make,
realize.
You don't have a cross-appeal on the other one, right?
Yes, it's the same cross-appeal.
Oh.
Exactly the same
Then we'll
cross-appeal.
give you, how about if I just take off 15 minutes, 5 minutes off of what next and put it on this one?
You can
Okay.
do that, that's fine,
Okay.
sure.
You have 5 minutes. No, you
Oh,
can do your
I
cross-appeal
continue now, that's right, okay. Well, I used 15 minutes so far, or 20?
You've just used 20.
Wow. All right, so.
Time flies when you're having fun.
It sure does. Well, it's the new courtroom and everything,
So I'm going to give you 5, so this will be 20, you're going to get 5 now, and then.
There'll be 15 left
There'll be
then
15.
for next, that's fine. Okay. There are a couple things I want to point out to show that the set-off that the judge administered just cannot be right. The judge awarded, these 3 separate judgments, he awarded consequential damages, which are largely the Veselios moving, loss of the use of the home, and the various things connected with having to evacuate the home. All right. Point number 1, his award for consequential damages on these 3 judgments, it was a different amount on each one, but it was $800,000 approximately on 2 of them, and $1.8 million on the other. That's the duplicative damages the judge found with his interpretation method. He subtracted $2.7 million. How can you do that? You don't have $2.7 million in duplicative damages. So I wrote in the brief, that means that under that method, if you had $1,000 of duplicative damages, you'd still subtract $2.7 million. And counsel for Addison wrote, that's right. It doesn't matter what the amount of duplicative damages is. That appears in the brief. That's not justice. The idea of a set-off is to not allow the recovery for the same damages twice. Even if we assume that the settled subcontractors were somehow responsible for water intrusion and mold that caused the Veselios to have to leave the home, and the resulting consequential damages of $800,000 up to $1.8, how can you subtract 2.7 for that? And if you do subtract all of that, you're saying that Addison...
Are you still arguing on this point and not your cross-appeals?
This is the cross appeals.
Okay,
Yes.
okay.
And so you're saying that Addison is responsible, who is the party responsible for waterproofing in this house and didn't do it, which is what caused the mold and the water intrusion. You're saying they're not responsible at all for the Vaselios having to leave the house because of mold and all the consequential damages that related to that. So that's reason number one. The set-off is, in any event, even if the judge's analysis is somehow correct, he set off too much. Second, the judge didn't look at the subcontractors individually. You mentioned the pool company. Maybe there were leaks in the papers, but that had nothing to do with the house. The reason the consequential damages occurred is because the Vaselios couldn't live there. Because of mold, they were getting sick. There was water intrusion, and the house had to be partially deconstructed. The windows and doors had to come out so they could put a waterproofing membrane in called Kevlar, which should have been put in when they built the home. The pool guy's cracks in his pool and whatever was going on there had nothing to do with the need to leave the home, with the consequential damages. The judge didn't, he heard that, and he said, well, that makes sense, but it says in your complaint that you sued all these defendants for all these damages.
And the releases didn't delineate this with any specificity.
Well, but they said in their scope of work, right? And so the scope of work of the pool guy, for example, has nothing to do with waterproofing the home. So how do you get consequential damages against that guy? The electrician, same thing, electrical conduits. He had nothing to do with waterproofing. This is a waterproofing case. And all of the consequential damages relate to the lack of waterproofing in this home, which was sitting on the ocean. That's what this case is really about. So the judge didn't look at the facts and let that help him determine whether there were duplicative damages. He just used generic language in a complaint and generic releases and said, the complaint.
Well, as we said in Cornerstone, in that case, I guess it was the bank could have protected itself by delineating what the settlement was for. But when you don't.
But nobody withheld damages in that case. That was a very simple case. Somebody embezzled money from the company by writing bogus checks, right? And then the bank cashed them. So the company sued the employee who did the embezzlement and the bank that cashed the checks. Same exact damages. And so, unless you could show that the damages caused by the employee were somehow different and delineate, I don't know how you could do that.
When you say withheld damages, you mean that you actually had 5.1 million and you only got 2. Well, of course, that's a matter of settlement. Maybe you really didn't have 5.1 million.
The evidence is that we did. That was an evidentiary hearing on set-off. The other side had every opportunity to put on their own evidence that we didn't have 5.1. Before trial, the damages expert put together a spreadsheet. It was a thing of beauty. It also took a magnifying glass to read. It was 20 or 30 pages of tiny detail with every defendant in the case allocating damages. This is before the settlement. The parties had that. They cross-examined this witness for 11 days in deposition. They had all the information, yet they put on no evidence when Mr. Slider, this expert, took the stand at the set-off hearing and said, these are the damages we attributed to the settled subcontractors.
Thank you.
Okay, thank you, Judge.
Thank you, Judge Warner, because I was looking for that quote from Cornerstone, because honestly, all of these arguments, they're attacking the trial judge for making a determination based upon what Cornerstone and all of these other cases say. These cases require the judge to do what he did on the set-off because there was no differentiation. And I want to address this evidentiary hearing that counsel is talking about, in which he says they proved there were $5.1 million in damages that they didn't put on during the trial. Well, number one, that evidentiary hearing, I think that was a kindness by the judge, because the judge had already ruled that based on Cornerstone and the other cases and the undifferentiated settlement agreements, that the defendants would get a full settlement of the settlement amounts. So, but on motion for rehearing, counsel asked for an evidentiary hearing. The court gave it to him. This was long after the trial and long after the court had ruled on the set-off. And throughout his briefing today, counsel is saying it was undisputed that we withheld $5.1 million in our damages, and this just isn't fair. Well, the law is the law. The law requires that the court grant a set-off for the entire amount of the settlement unless the parties have allocated in the settlement. There's a couple of cases where the parties tried to do it later, which I think is very analogous to trying to hold a post-judgment evidentiary hearing. The Nauman case, for example, there's another one, I think it was the Dionisi case. Both involved attempts to reallocate damages that were paid by a settling co-defendant or subcontractor to try to avoid the same problem that counsel is basing his cross appeal on. And the court said, no, you can't do that. You cannot go after the fact and say, well, this is really what the settlement was supposed to pay, this damage and this damage, but not these damages. The courts have said you can't do that.
Is there something in the record that shows that you all acceded to them not putting on these damages?
I can tell you that the motion in limine was granted. I don't think we opposed it, because if you really read the motion in limine, that, by the way, it's miscited in the plaintiff's brief. I don't have it here, but I think it's cited in our brief. That was basically, I think, as one of your honors pointed out earlier, it was to prevent discussion of settlement in front of the jury, which would prejudice the plaintiff. I don't think we opposed that, but throughout the trial, there was an attempt to introduce evidence that was pertaining to the scope of work of one of these settling defendants. There was many sidebars. In some cases, the evidence was allowed, in some cases it wasn't, but at every juncture, the parties reminded each other in the court that, oh, we're going to deal with set-off after trial. And I would also point out that although Mr. Slider later, post-trial, post-judgment, testified that when he testified at trial, he didn't include these damages that they're now trying to argue were not settled. The plaintiff introduced exhibit number 511, which is a total list of every check that Mr. Viccellio paid, which he claimed, which were his expenses and damages. So it is not at all clear that the trial was solely on scope of work addressed to these defendants and didn't include anything regarding the settling defendants. And I will also point out that the motion in limine was addressing what was going to happen in the jury trial. This was an odd kind of trial. Most of it was jury. A few times during the trial, the court took evidence outside the hearing of the jury as part of the non-jury trial, and then after the jury verdict, continued on with the non-jury trial. But there were instances in which the settlement amounts for these settling subcontractors was introduced, and the motion in limine, as I said, it only applied to the jury trial if you look at the motion. But I think the bottom line here is that these arguments come too late. The arguments that we only received X amount from this settling defendant based upon this particular scope of work, you can't make those arguments, you can't allocate those settlement amounts after you've entered into a settlement agreement that's undifferentiated. The Vicellios are asking this court to go contrary to the long line of cases in this court and every other court that has decided the issue and say, well, make an exception for me because this is unfair. But as pointed out in the Cornerstone case, it said, you could have dealt with this. You could have written a complaint differently. You could have written a settlement agreement differently. There may have been strategic reasons not to do it in a different way, but the fact is, the law is the law. And, the Vicellios have not given you a reason to take away these settlement set-offs. I think my time is up, but I would also remind the court that I have an interest recalculation argument that is important to me. And the Escadot case out of the 3rd District explains why set-off should come first and then interest. Thank you.
Okay. Thank you, both. And we'll let you sit down and start again? Is that, or we've got two different